Number 9, we are going to discuss about the Constitution as a living document. So, in this chapter, you will see how the Constitution has worked in the last 69 years and how India has managed to be governed by the same Constitution. After studying this chapter, you will find out that the Indian Constitution can be amended according to the needs of the nation, according to the need of the time. And though many such amendments have already taken place, and the Constitution has remained intact and its basic premises have not changed. The judiciary has played an important role in protecting the constitution and also in interpreting the constitution, and the constitution is a document that keeps evolving and responding to the changing situations. उसके बाद जो नेक्स्ट है वो क्या है? उसके बाद जो है वो ये है, इट सीम्स टू मी दैट कॉन्स्टिट्यूशन चेंजेस आर वेरी क्लोजली लिंक टू द पॉलिटिकल डेवलपमेंट. उसके बाद जो नेक्स्ट है वो क्या है? आर कॉन्स्टिट्यूशन स्टेटिक? इट is not uncommon for the nation to rewrite their constitutions in response to changed circumstances or change of the ideas within the society or even due to the political upheavals. The Soviet Union had 4 constitutions in the life of 74 years: 1918, 1924, 1936, and 1977. In 1991, the rule of the Communist Party of the Soviet Union came to an end, and soon the Soviet Federation disintegrated. After this political upheaval, the newly formed Russian Federation adopted a new constitution in 1993. But look at India. The Constitution of India was adopted on 26 November 1949. Its implementation formally started from 26 January 1950. More than 69 years after that, the same constitution continues to function as the framework within which the government of our country operates. It is that our constitution is so good that it needs no change. Was it that our constitution makers were so far-sighted, and why is that they had foreseen all the changes that would take place in the future? In some sense, both the answers are correct. It is true that we have inherited a very robust constitution. The basic framework of the constitution is very much suited to our country. It is also true that the constitution makers were very far-sighted and provided for the many solutions for the future situations. But no constitution can provide for all the eventualities. No document can be such that it needs no change. France had numerous constitutions in the last 2 centuries after the Revolution and during the Napoleonic period. France underwent continuous experimentation about the constitution, and the post-revolution constitution of 1793 is called the period of the First French Republic, and then commenced the Second French Republic in 1848. The Third French Republic was formed within a new constitution in 1875. In 1946, with the new constitution, the Fourth French Republic came into being. Finally, in 1958, the Fifth French Republic came into being with the yet another constitution. उसके बाद जो next है वो क्या है? This is, I know that the Constitution of the US came into existence more than 200 years ago, and so far it has been amended only 27 times. It isn't that very interesting? Then how does the same constitution continue to serve the country? One of the answers to such questions is that our constitution accepts the necessity of the modifications according to the changing needs of the society. Secondly, in the actual working of the constitution, there has been enough flexibility of interpretations. Both political practice and judicial rulings have shown maturity and flexibility in implementing the constitution. These factors have made our constitution a living document rather than a closed and static rule book. In any society, those responsible for drafting the constitution at a particular time would face one common challenge. The provisions of the constitution would naturally reflect efforts to tackle the problems that the society is facing at the time of making the constitution. At the same time, the constitution must be a document that provides the framework of the government for the future as well. Therefore, the constitution has to be able to respond to the challenges that may arise in the future. In this sense, the constitution will always have something that is contemporary and something that has a more durable importance. At the same time, constitution is not a frozen and unalterable document. It is a document made by the human beings and may need revisions, changes, and re-examinations. It is true that the constitution reflects the dreams and aspirations of the concerned society. It must also be kept in mind that the constitution is a framework for the democratic governance of the society. In this sense, it is an instrument that societies create for themselves. This dual role of the constitution always leads to difficult questions about the status of the constitution. It's so sacred that nobody ever can change it. Alternatively, is it so ordinary an instrument that it can be modified just like any other ordinary law? And the makers of the Indian Constitution were aware of this problem, and so to strike a balance, and they placed the Constitution above the ordinary law and expected that the future generations will respect this document. At the same time, they recognized that in the future, this document may require modifications. Even at the time of writing the Constitution, they were aware that on many matters, there were differences of opinion. Whenever society would veer toward any particular opinion, a change in the constitutional provisions would be required. And thus, the Indian Constitution is a combination of both the approaches mentioned above, that the Constitution is a sacred document and that it is an instrument that may require changes from time to time. In other words, our Constitution is not a static document. It is not the final word about everything. It is not alterable. Now check your progress. After reading the section above, a number of students in the class were confused. They made the following statements. What would you say about each of these statements? The constitution is like any other law. It simply tells us what are the rules and regulations governing the government. The constitution is the expression of or the will of the people. So there must be a provision to change the constitution after every 10 or 15 years. The constitution is a statement of the philosophy of the country. It can never be changed. And the constitution is a sacred document. Therefore, any talk of the changing it is against democracy. Now, how to amend the constitution? Article 368. Parliament may exercise its constituent power, amend by the way of addition, variation, or repeal any provision of this constitution in accordance with the procedure laid down in the article. फिर उसके बाद जो नेक्स्ट है वो क्या है, इधर जो नेक्स्ट है ये है, आई डोंट अंडरस्टैंड हाउ अ constitution can be flexible or rigid. Isn't it politics of that period which makes the constitution rigid or flexible? उसके बाद जो नेक्स्ट है वो क्या है, we have already seen that the makers of our constitution wanted to strike a balance. The constitution must be amended if so required, but it must be protected from the unnecessary and frequent changes. In other words, they wanted the constitution to be flexible and at that same time rigid. Flexible means open to changes and rigid means resistant to changes. A constitution that can be very easily changed or modified is often called flexible. In the case of constitutions which are very difficult to amend, they are described as rigid. The Indian Constitution combines both these characteristics, and the makers of the Constitution were aware of the fact that there may be some faults or mistakes in the Constitution. They knew that the Constitution could not be totally free of errors. Whenever such mistakes would come to light, they wanted the Constitution to be easily amended and to be able to get rid of these mistakes. And then there were some provisions in the Constitution that were of temporary nature, and it was decided that these could be altered later on once the new parliament was elected. But at the same time, the constitution was framing a federal polity, and therefore the rights and powers of the states could not be changed without the consent of the states. Some other features were so central to the spirit of the constitution that the constitution makers were anxious to protect these from the change, and these provisions had to be made rigid, and these considerations led to the different ways of amending the constitution. Here, I don't understand how a constitution can be flexible or rigid. Isn't it the politics of the period which makes the constitution rigid or flexible? How to amend the constitution? Similar to the ordinary law, simple majority in the parliament as mentioned in the some articles, special majority in the parliament in both the houses separately as per the article 368, and special majority legislatures of half the states, article 368. Now there are many articles in the constitution which mention that these articles can be amended by a simple law of the parliament. No special procedure for the amendment is required in such cases, and there is no difference at all between an amendment and an ordinary law. These parts of the constitution are very flexible. Read carefully the following text of the some articles of the constitution. In both these articles, the wording by law indicates that these articles can be modified by the parliament without resources to the procedure laid down in the article 368. Many other articles of the constitution can be modified by the parliament in the simple manner. Now article number 2, parliament may by law admit into the union new states, and article number 3, parliament may by law increase the area of any state. For amending the remaining parts of the constitution, provisions has been made in article 368 of the constitution. In this article there are two methods of amending the constitution, and they apply to two different sets of the articles of the constitution. One method is that amendment can be made by any special majority of the two houses of the parliament, and the other method is more difficult. It requires special majority of the parliament and consent of the half of the state legislatures. Note that all amendments to the constitution are initiated only in the parliament. Besides the special majority in the parliament, no outside agency like a constitution commission or a separate body is required for the amending the constitution. Similarly, after the passage in the parliament and in some cases in the state legislatures, no referendum is required for the ratification of the amendment. उसके बाद जो नेक्स्ट है व्हाट हैपेंस इफ सम स्टेट्स वांट एन अमेंडमेंट टू द कॉन्स्टिट्यूशन, कांट दे प्रपोज एन अमेंडमेंट? आई थिंक दिस इज अनदर एग्जांपल ऑफ द फेवरिंग दिस सेंटर अगेंस्ट द स्टेट्स. इसके बाद जो नेक्स्ट है वो क्या है, नेक्स्ट वी वर स्टडिंग यहाँ पे था सिमिलरली after the passage in the parliament and in some cases in the state legislatures, no referendum is required for the ratification of the amendment bill. Like all other bills goes the president for his assent, but in this case the president has no power to send it back for the reconsideration, and these details show how rigid and complicated the amending process could have been. Our constitution avoids these complications, and this makes the amendment procedures relatively simple. But more importantly, this process underlines an important principle: only elected representatives of the people are empowered to consider and take final decisions on this question of amendments, and the sovereignty of elected representatives, like parliamentary sovereignty, is the basis of the amendment procedure. Now, special majority. In this chapter on the election, executive and judiciary, we have come across provisions that require special majority. Let us repeat again what special majority means. Ordinarily, all businesses of the legislature requires that a motion or resolution or bill should get the support of the simple majority of the members voting at that time. Suppose that at the same time of voting on a bill, 247 members were present in the House and all of them participated in the voting on the bill, then the bill would be passed if at least 124 members voted in the favor of the bill. Not so in the case of an amendment bill. Amendment to the constitution requires two different kinds of special majorities. In the first place, those voting in favor of the amendment bill should constitute at least half of the total strength of that house, and secondly, the supporters of the amendment bill must also constitute two thirds of those who actually take part in voting. Both houses of the parliament must pass the amendment bill separately. In the same manner, there is no provision for a joint session. For every amendment bill, this special majority is required. Can you see the significance of this requirement in the Lok Sabha? There are 545 members. Therefore, any amendment must be supported by a minimum of 273 members. Even if only 300 members are present at the time of voting, the amendment bill must get the support of 273 out of them. But imagine that 400 members of the Lok Sabha have voted on an amendment bill. How many members should support the bill to get the bill passed? In addition to this, both the houses must pass the amendment bill with the special majority separately. This means that unless there is sufficient consensus over the proposed amendment, it cannot be passed. If the party in power enjoys very thin majority, it can pass legislation of its choice and can get budget approved even if the opposition does not agree. But if it would need to take at least some opposition parties into the confidence if it wanted to amend the constitution. So the basic principle behind the amending process is that it should be based on the broad support among the political parties and parliaments. Now here I am fed up with the business of special majority. It forces you to make difficult calculations all the time. Is it politics or maths? Now here, if those who are dissatisfied with the constitution have only to obtain 2/3 majority, and if they cannot obtain even that, their dissatisfaction with the constitution cannot be deemed to be shared by the general public. Note that Dr. Bhimrao Ambedkar is talking here not only of parliamentary majority, he refers to sharing of the views by the general public. This indicates that behind the majority there is the principle of public opinion that governs decision making. डॉक्टर अम्बेडकर ने ये 25 नवंबर 1949 यहाँ पे ये सारी बातें हुई थी. एंड देन उसके बाद जो है नाउ नेक्स्ट इज रेटिफिकेशन बाय द स्टेट. नाउ रेटिफिकेशन बाय द स्टेट फॉर सम आर्टिकल्स इन द कॉन्स्टिट्यूशन स्पेशल मेजोरिटी इज नॉट सफिशिएंट व्हेन एन अमेंडमेंट एम्स टू मॉडिफाई एन आर्टिकल रिलेटेड टू द डिस्ट्रीब्यूशन ऑफ पावर्स बिटवीन द स्टेट्स एंड द सेंट्रल गवर्नमेंट और आर्टिकल्स रिलेटेड टू द representation. It is necessary that the states must be consulted and that they give their consent. We have studied the federal nature of the constitution. Federalism means that power of the states must not be the mercy of the central government, and the constitution has ensured this by providing that legislatures of half the states have to pass the amendments bill before the amendments comes into effect. We can say that for some parts of the constitution, greater or wider consensus in the polity is expected, and this provision also respects the states and give them participation in the process of amendment. At the same time, care is taken to keep this procedure somewhat flexible, even in its more rigid format. Consent of only half the states is required, and simple majority of the state legislature is sufficient. Thus, the amendment process is not impracticable even after taking into the considerations this more stringent condition. We may summarize that the Constitution of India can be amended through the large-scale consensus and limited participation of the states. The founding fathers took care that constitution would not be open to easy tampering, and yet future generations were given the right to amend and modify according to the needs and requirements of the time. Here, check your progress for making the following amendments to the Constitution of India. What conditions need to be fulfilled? Place a tick mark in the chart wherever applicable. ये है पॉलिटिकल साइंस एंड हम पढ़ रहे हैं कॉन्स्टिट्यूशन एज अ लिविंग डॉक्यूमेंट. उसके बाद इधर जो है सब्जेक्ट ऑफ अमेंडमेंट स्पेशल मेजोरिटी रेटिफिकेशन बाय द स्टेट्स, ये बताना है. सिटीजनशिप क्लॉज, राइट टू फ्रीडम ऑफ रिलीजन, चेंजेस इन द यूनियन लिस्ट, चेंजेस इन द स्टेट बाउंड्रीज एंड प्रोविजंस रिगार्डिंग टू द इलेक्शन कमीशन. नाउ व्हाई हैव दीज बीन सो मेनी अमेंडमेंट्स? व्हाई हैव देयर बीन सो मेनी अमेंडमेंट्स? Why was our constitution amended so many times? Is there something wrong with our society or with the constitution? किसके साथ प्रॉब्लम है? On 26 January 2024, the constitution. ओके, आप साइंस के स्टूडेंट हो, पीसीएम अभी 12th 11th में हो. On 26 January 2024, Constitution of India completed 75. On 26 January 2024, the Constitution of India completed 74 years of its existence. तो फिर 2025 में कौन सा हुआ? 75. एंड 2026 में कौन सा हुआ? 76. लेकिन इस बार तो हम बोल रहे हैं कि हम अपना 77th जो है 77वां जो है गणतंत्र दिवस मना रहे हैं. So here on 26 January 2024, the Constitution of India completed 74 years of its existence. तो इसका मतलब ये 75th मनाया गया होगा इस टाइम पे. फिर उसके बाद ये 2025 में 76 और अभी जो है 77th और आगे जो है 78th होगा इस तरीके से. सो ऑन 26 जनवरी 2024 द कॉन्स्टिट्यूशन ऑफ इंडिया कंप्लीटेड 74 years ऑफ इट्स एग्जिस्टेंस. इन दीज ईयर्स इट हैज़ बीन अमेंडेड 106 टाइम्स. 106 बार बदल गया ये 74 सालों में ही. गिवन द relatively difficult method of amending the constitution and the number of amendments appears quite high. Let us try to find out how it is that so many amendments took. I am from Sonipat और tomorrow is our Republic Day. So in this way ये constitution as a living document जो है आपके लिए भी important है. तो let us try to find out how it is that so many amendments took place and that what it means. Let us first look at the brief history of the amendments. Look carefully at the graphs below. The same information is presented in two different ways. The first graph depicts the number of constitution amendments made every 10 years. The bar indicates the number of amendments in that period. And the second graph depicts the time taken for every 10 amendments. The bar depicts the year taken for the amendments. You will notice that the 2 decades from 1970 to 1990 saw a large number of amendments. On the other hand, the second graph tells one more story. 10 amendments took place between a short span of 3 years between 1974 and 1976. And again, in just 3 years from 2001 to 2003, 10 amendments took place in the political history of our country. These two periods are remarkably different. And the first was a period of Congress domination, and Congress party had a vast majority in the parliament. It had 352 seats in the Lok Sabha and majority in most state assemblies. On the other hand, the period between the 2001 and 2003 was a period marked by the coalition politics. It was also a period when different parties were in the power in the different states, and the bitter rivalry between the BJP and its opponent is another feature of this period. And yet this period saw as many as 10 amendments in just 3 years. So the incidence of amendments is not dependent merely on the nature of majority of the ruling party alone. Here graph 1 shows amendments per decade. यहाँ पे जो है ऐसे दिखाया गया है. ठीक है. फिर उसके बाद जो नेक्स्ट है वो दिखा रहा है इधर भी क्या है ये अमेंडमेंट्स मतलब ग्राफ 2 ईयर्स टेकन फॉर एवरी 10 अमेंडमेंट्स. उसके बाद जो नेक्स्ट है वो क्या है इधर there is always a criticism about the number of amendments. It is said that there have been far too many amendments to the Constitution of India. On the face of it, in the fact that 106th amendment took place in 74 years does seem to be somewhat odd, but the two graphs above suggest that amendments are not only due to the political considerations. Bearing the first decade after the commencements of the Constitution, every decade has witnessed a steady stream of amendments, and this means that irrespective of the nature of politics and the party in the power, amendments were required to be made from time to time. Was this because of the inadequacies of the original Constitution? Is the Constitution too flexible? Now, contents of amendments made so far. Amendments made so far may be classified in 3 groups. In the first group, there are amendments which are of technical or administrative nature and were only clarifications, explanations, and minor modifications, etc., of the original provisions. And they are amendments. They are amendments only in the legal sense, but in matter of fact, they made no substantial difference to the provision. This is true of the amendments that increased the age of retirement of High Court judges from 60 to 62 years. 15th Amendment. Similarly, salaries of judges of the High Courts and the Supreme Court were increased by an amendment, 54th Amendment. We may also take the example of the provision regarding the reserved seats in the legislatures for scheduled castes and scheduled tribes. The original provision said that that these reservations were for a period of 10 years. And however, in order to ensure the fair representations of these sections, it was necessary to extend this period by 10 years. And thus, after every 10 years, an amendment is made to extend the period by another 10 years. And this has led to the 6 amendments so far. But these amendments have not made any difference to the original provisions. In this sense, it is only technical amendments. Okay? Now, I think we should be looking at the changes rather than the number of amendments. That is what we should be doing as students of politics. Now, here I am still confused. If there is a written constitution, where is the scope for the different interpretations, or do people read in the constitution what they want to be there? Now, do you remember that the discussion in this chapter 4 about the role of the president? In the original constitution, it was assumed that in our parliamentary government, the president would normally abide by the advice of the Council of Ministers, and this was only reiterated by a later amendment when Article 74 clause 1 was amended to clarify that the advice of the Council of Ministers will be binding on the president, and president shall act in the accordance with the advice of the Council of Ministers. In reality, this amendment did not make any difference, because that is exactly what has been happening all through. The amendments was only by the way of explanation. Now, differing interpretations. A number of amendments are a product of different interpretations of the constitution given by the judiciary and the government of the day. When these clashed, the parliament had to insert an amendment underlining one particular interpretations as the authentic one. It is a part of the democratic politics that various institutions would interpret the constitution, and particularly the scope of their own powers in a different manner. Many times the parliament did not agree with the judicial interpretations and therefore sought to amend the constitution to overcome the ruling of the judiciary. In the period between the 1970 and 1975, the situation arose frequently. In the chapter on the judiciary, you have already studied that the issues of differences between the judiciary and the parliament. One was the relationship between the fundamental rights and directive principles, the other was the scope of right to private property, and the third was the scope of parliament. Power to amend the constitution. In the period 1970 to 1975, the parliament repeatedly made amendments to overcome the adverse interpretations by the judiciary. It may be kept in mind that during this period 1970 to 1975, many political events were unfolding, and thus this history of our constitution development can be fully understood in the context of the politics of that period. You will know more about these constitutions in the next year when you study the political history of the independent India. Amendments to the political consensus. Thirdly, there is another large group of the amendments that have been made as a result of the consensus among the political parties, and we may say that this consensus made it necessary that some changes had to be made in order to reflect the prevailing political philosophy and aspirations of the society. In fact, many of the amendments of the post 1984 period are instances of this trend. Remember our question above about the peculiarity that even when there were coalition governments, this period saw so many amendments, and the reason is because many of these amendments were based on an evolving consensus on the certain issues, starting with the Anti-Defection Amendment, 52nd Amendment, and this period saw a series of amendments in spite of the political turbulence. Now, apart from those, the Anti-Defection Amendments 52nd and 91st, and these amendments include the 61st Amendments, bringing down the minimum age for the voting 21 to 18 years, and 73rd and 74th Amendments, etc. in the same period. And there were some amendments clarifying that some expanding the scope of reservations in the jobs and admissions. After 1992 to 1993, an overall consensus emerged in the country about these measures, and therefore amendments regarding these measures were passed without much difficulty. 77th and 81st and 82nd Amendments. Now, controversial amendments. Our discussion so far should not create an impression that there has never been any controversies over amending the Constitution. In fact, amendments during this period, 1970 to 1980, generated a lot of legal and political controversy. And the parties that were in the position during the period 1971 to 1976 saw many of these amendments as attempts by the ruling party to subvert the constitution. In particular, the 38th, 39th and 42nd amendments have been the most controversial amendments so far, and these three amendments were made in the background of internal emergency declared in the country from June 1975. They sought to make basic changes in many crucial parts of the constitution. Here, so it is all about the politics. Didn't I say what this entire thing about constitution and amendments is linked to the politics rather than a law? So the 42nd Amendments was particularly seen as a wide-ranging amendments affecting the large parts of the Constitution, and it was also an attempt to override. It was also an attempt to override the ruling of the Supreme Court given in the Keshwananda case. Even the duration of the Lok Sabha was extended from 5 to 6 years, and in the chapter of the rights you have read about the fundamental duties. They were included in the Constitution by this amendment. The 42nd Amendment also put restrictions on the review powers of the judiciary. It was said at that time that this amendment was particularly rewriting many parts of the original constitution. Do you know that this amendment made changes to the preamble and the 7th schedule of the Constitution and 53 articles of the Constitution. Many MPs belonging to the opposition parties were in the jail within this amendment was passed in the parliament. In this backdrop, elections were held in 1977 and the ruling party Congress was defeated. The new government thought it is necessary to reconsider these controversial amendments and through the 43rd and 44th amendment cancelled most of the changes that were effected by the 38th, 39th and 42nd amendments. The constitutional balance was restored by these amendments. Now here, activity. Find out the amendments about the right to education RTE and the goods and services tax GST. What do you think that what do you think in the importance of these amendments here? Now, basic structure and evolution of the evolution of the constitution. One thing that has had a long lasting effect on the evolution of the Indian constitution is the theory of the basic structure of the constitution. You know already that the judiciary advanced this theory in the famous case of the Keshwananda Bharati. This ruling has contributed to the evolution of the constitution in the following ways. It has set specific limits to the parliament's power to amend the constitution. It says that the no amendment can violate the basic structure of the constitution. It allows the parliament to amend any and all parts of the constitution within his limitation, and it places the judiciary as the final authority in deciding if an amendment violates basic structure and what constitutes the basic structure. Here, so it is the judiciary that has the final word. Is this also judicial activism here? Now, it has specific limits to the parliament's power to amend the constitution. It says that no amendment can violate the basic structure of the constitution. It allows the parliament to amend any and all parts of the constitution within the limitations, and it places the judiciary as the final authority in deciding if an amendment violates the basic structure and what constitutes the basic structure. The Supreme Court gave the Keshwananda ruling in 1973. The past 4 decades, this decision has governed all interpretations of the Constitution, and all institutions in the country have accepted the theory of basic structure. In fact, the theory of basic structure is itself an example of a living Constitution, and there is no mention of this theory in the Constitution. It has emerged from the judicial interpretations. Thus, the judiciary and its interpretations have particularly amended the Constitution without a formal amendment. Now, all living documents evolve in this manner through the debates, arguments, competitions, and practical politics. Since 1973, the courts has in many cases elaborated upon this theory of the basic structure and given instances of what constitutes the basic structure of the constitution. In India, in a sense, the basic structure doctrine has further consolidated the balance between the rigidity and flexibility by saying that certain parts cannot be amended. It has underlined the rigid nature, while by allowing amendments to all the others, it has underlined the flexible nature of the amending process. Now here next is review of the constitution. Now review of the constitution जो है, in the late 90s efforts were made to review the entire constitution. In the year 2000, a commission to review the working of the constitution was appointed by the government of India under the chairmanship of a retired Chief Justice of the Supreme Court. Now Justice Venkata Chaliha, opposition parties and many other organizations boycotted the commission. While a lot of political controversies surrounded this commission, the commission stuck to the theory of basic structure and did not suggest any measures that would endanger the basic structure of the constitution. This shows the significance of the basic structure doctrine in our constitution practice. Now there are many other examples of how judicial interpretations changed our understanding of the constitution. In many decisions, the Supreme Court had held that reservations in jobs and educational institutions cannot exceed 50% of the total seats. This has now become an accepted principle, and similarly in the case involving reservations for the other backward classes, the Supreme Court introduced the idea of creamy layer and ruled that persons belonging to this category were not entitled to the benefit under the reservations in the same manner. And the judiciary has contributed to an informal amendment by interpreting various provisions concerning right to education, right to life and liberty, and the right to form and manage the minority in the educational institutions. And these are the instances of how rulings by the court contribute to the evaluation of the constitution. Here it is all wrong. First, they say that an amendment requires consensus, and now we see that judges changed the whole meaning of the constitution. Now next is here, check your progress. State whether the following statements are correct or not. After the basic structure ruling, Parliament does not have power to amend the constitution. The Supreme Court has given a clear list of the basic features of our constitution which cannot be amended. Judiciary has the power to decide whether an amendment violates basic structures or not. The Keshwananda Bharati ruling has set clear limits on the Parliament's power to amend this constitution. Constitution as a living document. We have described our constitution as a living document. What does that mean? Almost like a living being, this document keeps responding to the situations and circumstances arising from time to time like a living being. The constitution responds to the experience. In fact, that is the answer of the riddle we mentioned at the beginning about the durability of the constitution even after so many changes in the society. The constitution continues to work effectively because of this ability to be dynamic and to be open to interpretations and the ability to respond to the changing situation. And this is a hallmark of a democratic constitution. In a democratic, practices and ideas keep evolving over time and the society engages in experiments according to these. A constitution which protects democracy and yet allows for the evolution of the new practices becomes not only durable but also the object of the respect from the citizens. And the important point is has the constitution been able to protect itself and protect democracy? In the past 6 decades, some very critical situations arose in the politics and constitutional developments of the country. We have made a brief reference to the some of these in this chapter already. In terms of the constitutional legal issues, the most serious questions that came up again and again from 1950 was about the supremacy of the parliament. Here I get it. It's like a seesaw, or is it a game of tug of war? Here, क्या था? In a parliamentary democracy, the parliament represents the people, and therefore it is expected to have an upper hand over both executive and judiciary. At the same time, there is the text of the constitution, and it has given powers to other organs of the government, and therefore the supremacy of the parliament has to operate within this framework. Democracy is not only about vote and people's representation. It is also about the principle of rule of law. Democracy is all about the developing institutions and working through these institutions. All the political institutions must be responsible to the people and maintain a balance with each other. Now, contribution of the judiciary. During the controversy between the judiciary and the parliament thought that it had the power and responsibility to make laws and amendments for furthering the interests of the poor, backward, and the needy. And the judiciary insisted that all this has to take place within the framework provided by the constitution, and pro people measures should not bypass legal procedures, because once you bypass laws even with the good intentions, that can give an excuse to the power holders to use their power arbitrarily. And democracy is as much about checks on arbitrary use of power as it is about the well-being of the people. The success of the working of the Indian constitution lies in resolving these tensions. The judiciary in its famous Keshwananda ruling found a way out of the existing complications by turning to the spirit of the constitution rather than this later. If you read this constitution, you will not find any mentions of the basic structure of the constitution. Nowhere does the constitution say that such and such parts of the basic structure. In this sense, the basic structure theory is the invention of the judiciary. How did it invent such a non-existent thing, and how is that all the other institutions have accepted this during the past 4 decades? And therein lies the distinction between the letter and spirit. The court came to the conclusion that in reading a text or document, we must respect the intent behind that document. A mere text of the law is less important than the social circumstances and aspirations that have produced that law or document. The court was looking at the basic structure something without which the constitution cannot be imagined at all. And this is an instance of trying to balance the letter and the spirit of the constitution. Now, maturity of the political leadership. Our discussion of the role of the judiciary in the paragraph above brings out one more fact in the background of the fierce controversy and that tracked between the 1967 and 1973 parliament and the executive also realized that a balanced and long-term view was necessary. After the Supreme Court gave the ruling in the Keshwananda case, some attempts were made to ask the court to reconsider its ruling. When these failed, the 42nd Amendment was made out. Parliamentary supremacy was asserted, but the court again repeated its earlier stand in the Minerva Mills case 1980, and therefore even 4 decades after the ruling in the Keshwananda case, this ruling has dominated our interpretation of the constitution. Political interpretations of the constitution, political leaders, the government and the parliaments accepted the idea of the inviolable basic structure. Even when there was talk about the review of the constitution, that exercise could not cross the limit set by the theory of this basic structure. When the constitution was made, leaders and people of our country shared common vision of India. In the Nehru's famous speech at the time of the independence, this vision was described as a tryst with the destiny. In the Constituent Assembly also, all the leaders mentioned this vision, dignity and freedom of the individual. Of course, if there are no rights and no elections, the constitution won't make much sense. And if there is no well-being, elections and rights won't make sense. And this is how we understand the spirit of our constitution. Let us not ignore that there are many instances of the political immaturity as well does one have to first these. Now next is here, even within the Constituent Assembly, there were some members who felt that this constitution was not suited to the Indian situation. The ideals on which the draft constitution is framed have no manifest relation to the fundamental spirit of the India, and this constitution would not prove suitable and would break down soon after the being brought into the operation. And Lakshmi Narayana Sahu, ये 17 नवंबर 1949 की बातें हैं. उसके बाद जो नेक्स्ट है वो है economic equality, well-being of all people, unity based on the national integrity. This vision has not disappeared. People and leaders also hold to the vision and hope to realize. Therefore, the constitution based on this vision has remained an object of the respect and authority. Even after half a century, the basic values governing our public imagination remains intact. ठीक है, उसके बाद जो नेक्स्ट है वो क्या है कंक्लूजन में, there are still be debates about what constitutes basic structure. There is nothing wrong in such debates. We must remember that politics in a democracy is necessarily full of debates and differences. That is a sign of diversity, liveliness, and openness. Democracy welcomes debates. At the same time, our political parties and leadership have shown maturity in the setting limits to these debates. Because politics is also about the compromises and give and take, extreme positions may be theoretically very correct and ideologically very attractive. But politics demand that everyone is prepared to moderate their extreme views, sharp positions, and reach a common minimum grounds. Only then democratic politics becomes possible. Politicians and the people of India have understood and practiced these skills that has made the experience of working of the democratic constitution quite successful among the different organs of the government. There will always be competition over which one is more important than the others. They will also always fight over the what constitutes the welfare. Then they will also always fight over what constitutes the welfare of the people. But in the last instance, the final authority lies with the people. Their freedoms and their well-being constitute the purpose of the democracy and also the outcomes of the democratic politics. So this is all about the chapter we have discussed, Constitution as a living document. In the next video, we will be discussing about the philosophy of the Indian Constitution. Thank you so much for watching and stay connected.